the commercial world today, most of the corporate houses prefer going for an arbitration compared to the traditional litigation. However, a crucial question has now come up where parties should whether choose to resolve their disputes by including an arbitration clause in their agreement or resolving their disputes under the Commercial Courts Act. As a commercial litigant, the parties would always look into the aspect of time and cost and enforceability as their deciding factor. A recent survey conducted by the firm highlights certain dissatisfactions and reservations with the current arbitration mechanism, particularly in the field of timelines and costs. Domestic arbitrations in India under the 1996 Act, the timeline for a conclusion of an arbitration proceeding is 1 year, which is extendable for a period up to 6 months. However, the period only commences from the time of completion of the proceedings, which itself takes a lot of time. Today, after filing of statement of claim and statement of defense, in this process itself, the tribunal grants lot of extensions to the parties to file such pleadings. So far as the extendable period of 6 months is concerned, it has been observed that in the event the parties do not consent to such extensions, the courts are the only options left for the party to go and get these extensions. And from our practical experience, we see the courts have been really liberal in giving such extensions. Also, the time limit to complete a proceeding of under even 24 months is also sometimes extended by the courts on certain circumstances. The commencement of the arbitration proceeding is no less a hurdle for the parties. It is rare that the parties to an arbitration agreement come to a mutual agreement for appointment of the arbitrators. In this case, more often than not, we find that the courts are bestowed with the responsibility of appointing an arbitrator, which in different jurisdictions take different timelines. In some, we find it is appointed within a month, and in some jurisdictions, we find even in 1 year the arbitration cannot commence because the arbitrator is not appointed. In comparison to domestic arbitrations, a civil suit under the Commercial Courts Act 2015 over a specified value is strict within the timelines to be followed, whether it be the time limit to file a written statement, including the extendable period of totaling to 120 days, or it be adherence to the timelines as prescribed during the case management hearings. In these cases, bearing in mind the object of 2015 Act, courts have been seen not to incline in granting any adjournments or extensions so that the process gets delayed. Statistically, disposal of civil suits under 2015 have seen to increase in the past few years. Furthermore, another important aspect is even the courts are now bound to pronounce judgment within 30 days, which is extended only for another period of 30 days.
Likewise, the mechanism under the Arbitration and Conciliation Act provides for conciliation. The Commercial Courts Act also brings about provisions of pre-mediation settlement. If the parties before going to the court wants to settle their matters, they can obviously very well invoke these provisions and have the matter settled. In case the matters are not settled, then obviously the natural remedy is to go to the court, file the suit, and then the parties litigate. The next important factor in all this process is cost. Essentially, while doing the matter under the Commercial Courts Act, the parties are also at liberty to institute proceedings summarily and to seek summary judgment without prolonging the necessity for trial. This saves the cost. This also entails the party to essentially apply for commercial costs for litigating under Section 35 and 35A of the Commercial Courts Act, which is much less compulsive as the cost incurred in conducting the entire arbitration proceedings. We know that nowadays the arbitration proceedings, the costs are prohibited in as much as the counsel fees, the benefit charges, and other expenses. However, vis-a-vis the costs when we take into account while filing the suits, these are much less. As a matter of fact, another feature of the Commercial Courts Act, it bars all revision or any challenge to the temporary orders passed at any stage, and only when the matter is finally decided, then the parties can file a writ or challenge. The best object to have the Commercial Courts Act is that it has brought an end to the system of tariq with tariq. That is the reason which has given precedence to the domestic arbitrations. However, with the Commercial Courts Act, it appears that it is more a resolution of actual speedy disputes resolutions.